welcome today to our Handling Dismissals Due to Long-Term Sickness Absence webinar that is being facilitated by HR Recruit and Nathan Andrews from Okana. My name is Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan is going to discuss what a fair process looks like, consider the legal risks and whether dismissal is appropriate in all circumstances. If you do have any burning questions during the session, then please feel free to put them into the chat box facility, as we have left time at the end to go through a Q&A session. I'm now going to hand you over to Nathan, who will introduce himself and start the webinar. Thank you.
Thank you, Jo. Good afternoon, everyone. As Jo said, my name is Nathan Andrews. I'm the Managing Director for Okana. We're a specialist employee relations consultancy. You're meeting me today, but I will introduce you to, they're not here today, but I will introduce you via slides to two of my colleagues who I work with, just so you get to know who we are and what we do. What I'm going to do is just share my slides. So I'm going to just share my screen. Jo, can you see the
yeah.
main? Yeah, lovely. Okay, super. So thank you very much for joining today. We are going to be talking about handling dismissals, specifically relating to long-term sickness absence. Just to give you some guidelines around what we're discussing today, nothing we discuss should be considered specific legal advice. If you have specific issues within your business, you should consider taking specialist advice. And if you are dealing with complex matters, we would often suggest contacting an employment solicitor. Alternatively, you could contact Okana. We're a full service consultancy business, and we specialise in handling matters such as long-term sickness absence. But the presentation today is going to set out a general framework that you should follow in handling long-term sickness absence and specifically dismissals relating to those absences. So I just want you to bear in mind that, yeah, this is a general presentation and therefore shouldn't be seen as specific advice on any situation that you're dealing with in practice. So what we're going to cover in today's session is what is considered long-term absence. We're going to look at briefly the Acas guidelines, staying connected, a formal absence procedure, formal absence meetings, obtaining medical advice. We will briefly cover disability, and we'll look at return to work before covering dismissals. Now, we're setting out this process because these are things that you would need to do or to manage if you're handling long-term sickness absence in your business. So we can't get to dismissal before getting to understand the key steps that you need to take to work through the long-term sickness absence process. So the basis of our session today is we are going to make the assumption that the long-term absence is as a result of an employee having a diagnosed, recognised health condition. So it's an undisputed ill health. We're not going to be covering cases of malingering where, i.e., an employee may be off on sickness absence that's triggered long-term absence because they are essentially extending a period of short-term absence or pulling a sickie, as it were. So this is very much about dealing with a genuine long-term sickness absence. So first of all, what is long-term absence? When we're advising our clients, we always advise clients that, from our perspective, any absence that is 4 weeks or more, and that's consecutive weeks, should be considered and treated as long-term sickness. Some clients we work with, particularly in the hospitality sector, will often use a 3-week marker as their long-term sickness absence. But for us, the standard would be 4 or more consecutive weeks. And that should therefore, at that stage, trigger your long-term sickness absence policy if you have one. Now, regarding the Acas guidelines, when we work with client organisations and we work with organisations of varying sizes and descriptions, sometimes our clients don't have a long-term sickness absence policy. Now, long-term sickness absence policy should set out a clear framework for you to follow when handling long-term sickness absences. In the absence of a policy, what we recommend our clients do, and when we work with clients, we do the same, is that we follow the Acas guidelines. Now, within the Acas guide on handling disciplinary grievances at work, they do cover the handling of long-term sickness absence, and they provide a structured and robust framework that you can follow. Their framework consists of things such as advising the employer and employee to keep in regular contact with each other during periods of long-term sickness absence, It also suggests that the employee must be kept fully informed if there was any risk to their employment. And that is something we advise our clients of early on. If there is a risk to an employee's continuing employment due to long-term sickness absence, they should be advised of that. But that is very much later on in the process, not at the early stages. If the employee wishes to make contact, if the employer wishes to make contact with the employee's doctor, so their GP, for example, to obtain a medical report, we should follow the Access to Medical Reports Act and write to the employee, informing them that we want to access their medical records, and following that process as set out in the Acas guidelines. If you want specific information on that process, feel free to drop me an email and I can provide you with more detailed information. The other areas that we look at when handling the Acas guideline is making sure that if you do receive a medical report from the employee's GP, that you take that into consideration, and you also use that when you're looking at alternative work that may be available for the employee to undertake to facilitate a return to work. Where the employee's job can no longer be held open and there is no suitable alternative work available, then what we should be doing is informing the employee of the likelihood of dismissal. But again, that is much later on in the process. That just gives you a snapshot of the Acas guidelines around handling long-term absence. It's well worth having a read if you don't have an absence policy, because it does give you a number of steps to follow and it is a robust framework. So that's something we recommend our clients look at if they don't have a specific absence policy covering long-term sickness absence. So touch on staying connected during periods of long-term sickness absence. We always advise our clients that it is important when someone is on sick leave and they trigger long-term sickness absence that you maintain regular contact with them. What we've suggested that you should be mindful of the employee's need to have some space and potentially time to recuperate depending on why they are away from business. So it's advisable that you agree with the employee the method and frequency of how you're going to maintain contact during their sickness absence, and that should be mutually agreeable between both parties. Now, when we work with our clients, we specifically say to them that the purpose of early contact is to check in on the employee's welfare and identify what support they may need. It's also a good opportunity if you do have an EAP service provider in place that you signpost your employees to that, because that could offer them potentially some meaningful support during their period of absence. Regular contact is to help you identify why they're away from the business in some detail. Is there any support they specifically need? What's the nature of their illness or injury? Do they have an anticipated recovery period, for example? These are things that you should be noting down and holding on your case file so that you can refer to that information later on if needed. Also, the purpose of early contact is to also ideally identify what support is needed to help facilitate a return to work, and if that is possible. Now, when we work with clients, we absolutely stress that good record keeping is really important early on in the process. So we advise that you make notes, and that they should be detailed notes. You should capture the key information that is relevant and important to that particular period of sickness absence. And you should make sure that those notes are readily available should you need to refer back to them. Now, the key thing to remember when handling kind of early contact is that the approach here should be focused on supporting the employee. We, bearing in mind that the basis of this presentation is that there is an undisputed ill health episode. So we should be looking at how we can help support the employee while they are away from the business, and how we can potentially help facilitate a return to work when they feel ready and able to do so. So we want to be able to capture that approach in our documentation, that early on our approach was to support their return to work, is not about immediately managing them out of the business. So making sure you have a robust long-term sickness absence policy. Now, this is an interesting one, because when we work with clients who are maybe smaller in terms of headcount, they don't always have the necessary policies or frameworks that larger organisations do. But what we do recommend is that if you do have a sickness absence policy, it should provide you with a robust framework that you can follow and handle long-term sickness absence, so that you can maintain consistency in how you handle periods of sickness absence across your entire workforce. So just to give the 3 important points we always cover is how you will approach handling a case of long-term sickness absence, which should include holding a series of formal meetings and review periods and being really consistent with that. We sometimes see client organisations where they have held formal meetings or review periods, but they've been sporadic in nature. And what we're looking for here is a consistent approach, consistent contact with the employee. Also, it's important to remember that at formal meetings during sickness absence, the employee does have the right to be accompanied. So you should inform of that right if you're intending on holding meetings early on. And what we would suggest is that whilst typically the right to be accompanied is reserved for a fellow colleague or a trade union representative, if you have got an employee who is suffering with a serious health condition, it may be reasonable to allow them to be accompanied by an alternative person. It could be a family member or a friend, for example. That's just something to bear in mind. That would be what I would consider a reasonable adjustment if that is requested. So holding a formal review meeting itself. So these meetings can be complex and they can also be quite sensitive, especially if the employee is suffering with a serious health condition. So it's really important that whoever holds those meetings or has any involvement in meeting with the employee, they should be appropriately skilled and they should have the relevant training. That is really important. So I just want to cover off some key things that you need to remember. So the first one, again, I've just touched on it on the previous slide, is reasonable adjustments. If an employee makes a request to be accompanied by a relative or a friend, I would consider that a reasonable adjustment if they potentially have a disability, for example. So I wouldn't automatically say, no, it can only be a work colleague or a trade union representative. It's also worth remembering that if somebody is on long-term sickness absence and they are suffering with a health episode, they may not feel comfortable having a work colleague present and being privy to their personal information. So we often, when we handle matters for clients, we'll meet with the employee and they're often, supported by husband, wife, partner, might be a parent and so on. So that isn't something we automatically say no to. Another reasonable adjustment to consider, and I'm sure you're all aware of this already, is that it's the location of the meeting. So if you are holding a meeting with someone who's potentially disabled, maybe they have mobility issues, might not be reasonable to ask them to attend the workplace. So you could consider holding the meetings at the employee's home. What we would always suggest you do is if you are going to the employee's home, that there is more than one person in attendance. So you would have the person conducting the meeting and a note taker, for example. The other alternative is that you could conduct meetings via the telephone, Teams or Zoom, whichever enables you to meet the employee and to have a meaningful dialogue and contact with them throughout their period of sickness absence. Now, it's important to invite the employee to the meeting in writing. So we always recommend that a letter should go out inviting that employee to a formal absence meeting, and that letter should provide a clear summary of what you are going to do, what you're going to discuss when you meet with them. Again, make clear in the letter that they do have the right to be accompanied, and also I would ask them to be specific with you ahead of the meeting about who will accompany them, so you can plan accordingly and ensure that any invites, especially if you're meeting with them remotely via Zoom or Teams, can be sent to the right people in good time for them all to attend the meeting. In terms of handling the meeting generally, what we always suggest is that the nature of the employee's health condition and any changes which may prevent or impact a return to work in the near future should be discussed. You should also look at a likely return to work date and capture that information. That date may change, but it's good to capture early on what's the employee's thinking around when they may be able to come back to work. You need to think about whether medical evidence is required or needs to be obtained and the arrangements you might need to make for gathering that information. Where the employee is disabled, medical evidence is often required and it is helpful to the process. So again, if you believe that you're handling a situation where someone may be disabled, I would absolutely recommend that you look at obtaining relevant medical advice. That could be from the employee's GP. It may also be helpful to go to an occupational health specialist for support. You also want to explore the potential that the employee may be dismissed as part of the process and look at any alternatives to dismissal. So when we talk about alternatives to dismissal, and this is something you might talk about later on in the process, but we would typically cover off things like redeployment, ill health retirement, and we also take into consideration any PHIs, so permanent health insurance schemes you have in place that the employee may be eligible to receive. So these are things that you will talk about and consider later on. They should be on your radar And when you look at alternatives to dismissal, you want to be able to capture that in your records that you have done that. So what I would be typically saying to a client is, when we're at a later stage in the process, when we're looking at alternatives, let's be specific about what alternatives we've looked at and capture the detailed narrative around that, so you can refer back to that later on if you are challenged. Now, if you are looking at things like redeployment or reassigning duties, etc., you might need to talk about the impacts that might have on colleagues, their team, and their department more generally. It's also good practice when you're meeting with an employee to talk about the impacts of their absence on their colleagues, just so they understand more generally how their absence is impacting the business. Now, that's not to be done in a way that should make the employee feel bad about being absent, because bear in mind, we're making the assumption today that we are dealing with someone who has a genuine health condition. But it is important in our narrative to help the employee understand and to capture for the records the impact the absence is having on the business. You also want to not overlook company sick pay, so contractual sick pay scheme or SSP, and how long this is likely to continue for. That's something you should be discussing with the employee. So, for example, if you do have a contractual sick pay scheme in place, you need to be mindful and should be communicating with the employee how much contractual sick pay they have left, or if they want SSP, the same principle applies. You want to cover off how long they've been on sick leave, how much SSP they've had to date, and what is left remaining. So you're managing the employee's expectations around when a source of income is likely to expire for them. So there should be no surprises for the employee. So it's being open and honest with them. If you have any potential return to work programs that may assist the employee, again, they should be discussed at formal meetings and capture that in your notes. So we're going to hear me say that a lot throughout this session today. It's all about capturing detail in your notes. The record keeping is absolutely important. So when we're considering dismissal at the later stage of the process, what we would suggest is that you, before making any decision to dismiss, several meetings will have needed to have happened, and the focus of those meetings should absolutely capture the impact of the absence on the employer, the potential for dismissal. So again, that goes back to the earlier point I made when we were talking about the Acas guidelines. If you are at a later stage in the process and you feel that you're reaching a point where we're going to have to start thinking about dismissal, we need to be talking to the employee about that. So there should be no surprise at the end of the process when we're meeting with an employee saying, look, we can no longer continue as we are, and we are looking at dismissal as a potential outcome. The employee shouldn't be surprised. So they should have had meaningful dialogue and conversations with you throughout the process, and they should be very clear that the outcome could potentially be dismissal during the later stage. We should also have a clear view of the alternatives to dismissal. So again, just reiterating that, be clear, be specific, and capture it in your notes when you're looking at alternatives to dismissal, because dismissal really should be the absolute last option when you're handling a long-term sickness absence. And again, be really clear in how you obtain information, how you store that information. We often deal with cases of long-term absence where record keeping has happened, but it's not been kept in good order. So what I typically suggest is that when you're dealing with a specific case, set up a case file, keep information in date order. And it's often helpful. I mean, as a team, we use Excel. And so what we do is we keep a matrix, and we keep a list of all the documentation we have. We summarize that documentation. It's coded and it's kept in good order. So we know that later on, if we need to refer back to that, it's the file is set up in such a way that it is user-friendly and information can be found easily. So just touching on obtaining medical evidence. So a good, robust medical report should typically include the nature of the employee's condition, the impact of the employee's health condition on their ability to do their job. It should cover whether the medical practitioner believes the employee is disabled or not, as the case may be. It should also cover what adjustments could be made for you to consider as employers to facilitate return to work. And it should also cover the likely prognosis for recovery or a specific return to work date. So in terms of the provider of medical evidence, we always recommend that you're mindful to follow the correct procedures for obtaining access to medical records. That's really important. We also be selective in who you use to provide that medical evidence. So, for example, a specialist hospital consultant is going to be a good go-to person if you're wanting detailed information on a specific complex health condition that falls within that medical practitioner's area of expertise. If you're wanting to understand if an employee is disabled and how you can best support them as an organisation to return to work, then an occupational health specialist is likely to be more suitable. If you are dealing with a long-term sickness absence, we do work with an occupational health specialist, so we can point them in the right direction if you're looking to access the services of an occupational health specialist. Now, asking the right questions is really important when requesting medical reports. We often see GP surgeries who will charge for drafting a report, providing very little or limited information that has been requested. So the thing we always recommend to our clients when they are handling the drafting of documentation to gain access to medical records is there are two specific questions that should be asked. First one is, does the employee have a disability under the Equality Act? And we need to get that viewpoint from the medical practitioner. And the second one is, what adjustments can be made to facilitate a return to work? Bearing in mind, again, our focus is about helping someone return to work. It shouldn't be automatically on how can we dismiss this person and move on. If the report comes back without providing responses to the questions you have asked, or they're vague or ambiguous in nature, you do have the right to write back to the provider of that report and request that they provide responses to the information you have asked before you pay for the report. Some GP practices can charge quite high fees or costs for drafting those reports. So it's essential that when you're paying for that, it serves you a purpose and adds value to the process. Now, we deal with lots of cases where an employee will refuse consent for you to gain access to medical records. So what we always advise a client to do is that if an employee does refuse to give consent, don't force the issue. If you do force the issue and are seen to be harassing the employee, it could be perceived as a breach of the Access to Medical Records Act, and also could be seen as a breach of Article 8 of the Human Rights Act, which sets out an individual's right to privacy. So if an employee says, no, I'm not prepared to give you access, it's not worth harassing or pushing the point with the employee. However, what we would suggest is that it would be prudent to write to the employee, explain why you want access to medical information, that it's likely to be beneficial to them and the process for you to be fully appraised of their current health condition. That's a really important point to make to them. And you also need to make clear that any decisions made during the process, including dismissal, will only be based on the information which you have available to you at that time. So if the employee says, I'm not prepared to give you access to my medical information, they need to be clear that that could shape your decision-making because you're only going to be able to make choices and decisions based on the information you can see in front of you at that time. So taking that into consideration, I always suggest that we make clear to the employee that it is in their interests to have access to a detailed medical report, and it's actually going to benefit them in the long run. So I think that's something that you should absolutely make clear to an employee who's saying, look, I don't want to give you access to my medical records. And when I deal with that, sometimes I'll actually ask the employee, talk to me about what's the concern, what's the challenge for you about not wanting to give us access to that information, just so I can understand. It may be that there's a genuine concern and we're able to mitigate that for them and put their mind at rest so that they do give us access to the information we require. Now, what we always suggest is that when you do obtain medical information, it's really good practice to meet with the employee to discuss the report that you've received. So before taking any action with regard to that report, what we suggest you do is write to the employee and invite them to a meeting, explain what you want to review in terms of the report and why. Make sure that they are aware that they can be accompanied again to the meeting. That's really important. And discuss the content of the report with the employee with an open mind. Again, we're dealing with, we're making the assumption today that this is an undisputed health condition. So it's good to have an open conversation with them about the information that you've been given. And if you've got any questions from that information, ask the employee, work through that process with them. Again, take detailed notes from that meeting, making a copy of the notes available to the employee. What I always say is it's really important when you're taking notes of these meetings, make sure you send a copy to the employee and ask them to return a copy that is signed. And that copy can be scanned and emailed back to you, but you really want to have a signed copy held on file so that we're all clear that the notes you've taken, everybody agrees they serve as a fair reflection of what you have discussed when you've met with the employee. Now, in terms of disability, I'm not going to go into any detail on the Equality Act, just due to time, really. But it's just an important point to remember that if somebody is on long-term sick leave, it is likely and possible that they may be considered disabled within the meaning of the Equality Act. And so you don't want to overlook that. And just to give you, I'll provide some information here on the slide, which is in the second point, that the Act does contain, as we all know as HR practitioners, this broad definition of disability. And it's widely accepted that disability is a physical and mental impairment that lasts or is expected to last 12 months or more and has a substantial effect on the person's day-to-day life. So it's really important you take that into consideration, because you don't want to be seen as having made decisions that were discriminatory in nature based on disability. So take that into consideration. If you have got a situation that you're handling in your workplace and you think that disability is potentially going to be a major aspect of that employment matter, take advice and guidance. You can either come from a firm such as Okana, or it may be you have an employment solicitor you work with. Go and take professional advice and guidance before you make any decisions on whether you're going to terminate employment. So return to work. I'm going to cover this, although I know we're talking about essentially, dismissing at the end of a long-term sickness absence process, but you do want to not overlook the possibility of somebody returning to work. So what it says, the primary focus of long-term sickness absence is absolutely to facilitate a return to work wherever possible. And it's really important in the information that you gather as part of managing the long-term sickness absence process, you capture that narrative that actually your approach was to ultimately facilitate a return to work. And ultimately, if you get to the end of the process and that's not possible, then fine, you can demonstrate you've done what you can to help the employee come back to work in good time. Now, central to that is making reasonable adjustments. So when you're looking at return to work for people on long-term sick leave, you do need to be able to demonstrate you have looked at making reasonable adjustments to the employee's job role and in the workplace more generally, depending on their specific need or the specific circumstances of the employment matter that you may be dealing with in your place of work. And also, reasonable adjustment is essential if you are looking at or handling a situation where someone is disabled. Again, if you want, if you are at a stage when you're handling sickness absence where you think you've got somebody who may be able to come back to work and you need some advice, you can get in touch with us, or again, seek advice from, if you're not an HR practitioner, seek advice from your HR department or an HR consultant. And obviously, if you are an HR practitioner in an organisation and you've got some questions or challenges around the handling process, it's often worth just taking some professional advice, because long-term sickness absence can be very complicated depending on the situation that you're dealing with. So dismissal. Often in cases of long-term ill health, it is unclear if an employee is going to be able to return to work. And that can often then generate the need for conversations to be had about, where we're going with the process. So when you've reached the stage and you have followed a robust process, and that is really important, you need to be able to demonstrate you have absolutely followed a robust process, you've met with the employee, you've captured detailed information over an extended period of time. It may be that you have to consider dismissal. And again, as I've said previously, that should come as no surprise to the employee, because expectations should be managed clearly throughout the process. Now, dismissal should only be considered as an absolute last resort, and after you have considered alternatives to dismissal and you can demonstrate that. I often get asked by client organisations, what is a reasonable time frame to essentially dismiss somebody on long-term sickness absence? Now, I say it's really case dependent. It depends on the specifics of the case. I've never, we've had a client recently we worked with saying, look, I need to get this wrapped up within 6 months. We said, look, I can't guarantee you're going to get anything wrapped up within 6 months. And actually, in my experience, we've handled dismissals maybe within a 9-month window of that person going off sick. And that's been in what I would call very straightforward cases where the employee, had an undisputed health condition. It was absolutely clear that they were unlikely to make a return to work. And so at the 9-month window, we were able to reach a decision to dismiss. But actually, typically, it can take 12 months, if not sometimes a bit longer. It really does depend on the specifics of the employment matter. Now, I just want to cover some alternatives that you should be looking at when handling long-term sickness absence and when you're considering dismissal, which again should be later in the process. The first thing I would look at is permanent health insurance. So when you're looking at, should I be dismissing this person, it's worth checking, do you have a PHI scheme in place? I'm sure most of you will know that PHI provides income to employees who are unable to work due to long-term ill health, and that is typically paid via an insurance policy that is held by the employer. So in schemes that we've seen, if the employee satisfy the scheme criteria, and that can be complicated to get people accepted onto the scheme, but if they are accepted, then what we typically will see is that the employee will receive a fixed percentage of their usual annual salary, normally within the region of, say, 50%. So we always advise that employees should be very careful in considering dismissing someone who could be eligible to receive a PHI payment. So that's not a straightforward process. Dismissal in this case would be risky, as it would be likely to be seen that you are depriving the employee of their PHI benefit, which could lead to a breach of contract claim, as well as possible claims for unfair dismissal and disability discrimination. Now, what we do when we handle matters involving long-term sickness absence where a PHI scheme is in place is we will take advice ourselves. And we're lucky in the sense that within my team, I've got former employment lawyers and solicitors that we can access. But these matters are something we would discuss ourselves because it can be complicated when you've got PHI schemes in place. So what you want to be able to do is demonstrate that you have looked at that and taken that into consideration. Another alternative is potentially ill health retirement. So if your pension scheme offers the option for early retirement due to ill health, and the employee is a member of that scheme, then it's good practice to raise that with the employee and to have a conversation. Now, to qualify for early retirement due to ill health, typically you will need to arrange for a medical practitioner to confirm that the employee is not able to continue in their current employment or occupation due to ill health, and that is not likely to change in the near future. So it's not a straightforward process, but it is something you should look at and consider. Now, again, we always say there are complexities around pension scheme rules and an employee's entitlement which need to be considered, and I would always recommend you take professional advice on that point before proceeding. So so those are the points that you need to consider. And again, when you are considering them, just capture it in your notes, capture that narrative, things that you've looked at. I mean, I will often, when I meet, when we're case handling on behalf of our clients, when I meet with line managers, what I do is the meetings I have with line managers are minuted to. So we capture all the things we're talking about and things we're looking at, so we can demonstrate that we have really taken our time to consider the facts of the case, and we've looked at alternatives and all of that rich information that we want to be able to demonstrate and support our position if we're challenged later on is all there in the notes and it's held on the case file. So dismissal itself, once you've exhausted all possible alternatives, and we've discussed those today, you may be left facing the ultimate decision around whether we continue or not and whether you need to dismiss. And so what I would always say is, remember, dismissal for long-term sickness absence is a potentially fair reason for a dismissal under the Employment Rights Act. What you need to do is make sure you follow a fair process. You can't rush the process with long-term sickness absence. You just have to follow the process and be consistent with it. I think that's really important. So what we always suggest and recommend our clients be able to demonstrate is that they have acted reasonably in all of the circumstances. And the only way you're going to be able to demonstrate that robustly is by your record keeping. So that's a really important point I want to leave with you today. The decision to dismiss should only be reached following a number of absence review meetings having been held with the employee. So you want to be able to demonstrate that, again, this is not a rushed process. You've met with the employee, the meetings have been meaningful, you've had open communication with them, and you've looked at alternatives to dismissal, you've looked at options about how that employee may be able to return to work, and so on. You should also follow some key steps that I'm just going to outline for you before we come to an end today. But when you're holding a final meeting with the employee, what we always recommend is invite the employee to the meeting in writing. No, that sounds obvious, but we work with clients sometimes who don't have access to HR support where that's been missed. It's really important. Invite them in writing to the meeting. Make available to the employee any evidence you're going to be relying on during that dismissal meeting. So that will be, again, referring back to notes that you might want to touch on, medical information and so on. Make sure that is included and made available to the employee before you hold the meeting. Make it clear to the employee that the possible outcome of that meeting could be dismissal. So we don't obviously suggest that it's absolutely going to be dismissal, but they need to be clear that the potential outcome of this meeting could result in your employment being terminated. Absolutely inform the employee of their right to be accompanied. Make sure that any medical evidence you're going to be relying on is fully up to date and not from several months previously. Again, we've dealt with cases where a client organisation comes to us and says, look, I've got medical information, but actually it's 4 or 5 months old. And we would always recommend, no, go and get a more up-to-date medical report so you can demonstrate that any decisions you make was based on current information, specifically when you're talking about medical information. I think that's really important. Be clear with the employee, be factual. So, gather the information you've collected throughout the process and draw on the facts of the matter. Don't make assumptions or make decisions based on your opinion. So that's really important. Ask the employee if there's anything further that they want you to consider before you reach any decisions. I always advise that you take a brief adjournment when you're meeting with the employee at that final meeting and consider any further points made by the employee during the meeting. Sometimes it may be appropriate to adjourn longer. You might want to adjourn for 24 hours to consider specific points the employee has presented and asked you to consider before you reach your final decision. What I always recommend is that after your adjournment, reconvene, confirm your decision to the employee in person and set out their right to appeal and do all of that in writing. That's really important. Now, I appreciate that is a whistle-stop tour of handling the long-term absence process, but that is a solid framework. If you follow it properly and you are detailed in your record keeping and you handle the process in the right way, that should keep you safe in terms of as safe as you can be in handling dismissals for long-term sickness absence. What I would always recommend is, if you've got a complex matter, take some advice before making any final decisions. Thank you very much. I will pass back to Jo and I think we can go through some questions. Jo, I'm going to stop sharing. So
no problem. I don't know if we're going to get through them all, Nathan. There's loads.
Yeah, let's give it a go.
Right. Okay. So obviously some of this we're going back to the beginning. So Lisa has said that she's got a member of staff just fallen into long-term sickness, but she's still on probation. Do they have to extend probation until they return?
That's a good question. I mean, I would say yes, because you can't realistically assess her suitability for the role while she's away from the business. I mean, obviously, we won't go into specific details. Just I don't want to, put you on the spot in terms of giving confidential information away. But yeah, what I would say is you would extend that probation period and tell the employee that realistically we're going to have to extend your probation period because you're away on sick leave. Now, I know some people argue, well, actually the probation period is a bit null and void because the first 2 years of employment, the employee doesn't have a right to bring a claim for unfair dismissal. What I always suggest is if you have a probation period, extend it and do it properly and write to the employee and just explain the rationale for doing so. We've done something similar for a client recently where they've got a new employee who's gone on to sick leave and that has triggered just long-term sickness absence, and we said extend the probation period and support the employee's return to work ultimately. I hope that helps.
Anna's asked, so do you have any advice for long-term absence cases due to stress, in brackets work-related and personal, where the employee is continually signed off by the GP and requests no contact from the employer, and the occupational health supports this and says they are not fit to attend meetings?
Yeah, I mean, in those situations, what I would suggest is ultimately you can't continue open-ended, so you can't continue in that vein forever. So at some point, the employee is going to have to engage with you. What I would suggest that you do is in the early stages, if they're saying, I can't, it's not conducive to my mental health to attend meetings or engage with you at this stage, respect that in the early stages and demonstrate that you've respected that. And then later on, what I would suggest you do is then reach out to the employee and say, look, we do need to have contact with you and you have a right to have contact with them, and ask them how best you can have contact. Maybe, you could offer to deal with them in writing. Can they meet with you on Teams? Could they meet with you on the telephone? And it's really important when you offer those alternatives, capture it in writing. So if you're emailing them, print off that email, pop it on file, because you absolutely will need to have some contact with them, because ultimately the business, it's not realistic for the business to carry on long term in that vein. So if you I don't know where you are in the process, but yeah, early on, I would suggest respect their right to have some time away, especially if it's due to work-related stress. If there are ongoing concerns that you're aware of, can you investigate some of the issues that maybe have contributed to their work-related stress in their absence? Those are things you could be doing early on. But yeah, certainly what I would be recommending you do is that at some stage you're going to have to write to the employer and say, look, we need contact, and let's work at that. Let's work together on how that contact can happen. I hope that helps. Feel free though, if you to get in touch with us if you need any specific advice.
Linda's just put something very similar, Nathan, which I think you've answered. If Nathan's not answered that, Linda, could you just put another comment on there, and we'll cover that, try and cover that. Jessica has said, when else should we be accommodating other people to accompany the employee? She said that they had a request for a family friend with a case concerning mental health. Yeah,
so I mean, if the mental health, I mean, I typically take a broad brush approach here, that I think, look, if someone's off, if someone's on long-term sick leave and they don't feel comfortable having a colleague, then I'm prepared to make reasonable adjustments. Now, we work with some clients who can be a bit prescriptive about what that looks like, and so they will sometimes say, well, if they're disabled and they can prove they're disabled, then I might make adjustments. What I always advise is, make adjustments wherever possible. If you can demonstrate you've gone above and beyond what statutory regulations or employment law tells us we need to do, then what you're demonstrating is, as a business, you've been absolutely reasonable. So it's often in your interest to demonstrate. I call it gold standard. If you work with me, I'll say let's apply gold standard here to our interactions with the employee, and that is about going above and beyond and really being able to demonstrate reasonableness on your part as an employer, which is ultimately what you've got to do. You've got to demonstrate at the point that you may be dismissed, you need to demonstrate that this, any other reasonable employer would have reached the same conclusion, having followed the same process. I hope that helps.
Philip has asked, is the right to be accompanied an Acas guideline or best practice?
No Acas guideline, the employee, because these are formal meetings that will ultimately have an impact on their ongoing employment, essentially. So it is an Acas guideline. They are a company given the right to be accompanied at the meeting, because they're formal meetings. If it was an informal meeting where there's no specific outcome, then that's different. But because these meetings essentially are going to be taken into consideration later on in the process, potentially if you dismiss, that's why you would give them the right to be accompanied.
Lisa's asked, what's the usual review timescale?
Well, in terms of number of reviews or time between, if I go with time in between, again, it really depends on the specifics of the case. What you don't want to be seen to be doing is harassing the employee. So early on in the process, it might be that I would meet with the employee once in a month, but then if we get to maybe where they're off, bearing in mind that the 4-week window is the first point we'd meet with them. So it might be in the first 3 months you meet with them once a month. If you get to 3 months, I'd be looking at maybe increasing that, saying let's have a meeting every other week. And again, those meetings, can be held remotely, on the telephone, whatever needs to happen to facilitate communication. But it really is dependent on the employee. Now, sometimes employees will say, actually, I can't cope with all these regular meetings. And bearing in mind that as I'm advising today, I'm making the assumption that these are undisputed health conditions. It might be you make reasonable adjustments around what's reasonable in the circumstances. But yeah, I would say, once a month initially, I might increase that to, every other week, if I think there's going to be value and we might be able to facilitate a return to work, and therefore it's meaningful to have, frequent conversations, but definitely not less than once a month, in my view.
Sophie said that you've mentioned training for people holding those meetings. What sort of training would you recommend?
Yes, I mean, so what we do as a team for our clients is we hold half-day sessions on handling long-term absence, and the training would focus on, specifically if you're handling those meetings, it's just around how you show up, how you need to take into consideration things like are they disabled, how to handle meetings where there's particularly sensitive health situations. So we often expect a lot of line managers who have limited exposure to this type of work, and so for us, when we work with clients to deliver training seminars, about upskilling line managers to be able to lead those meetings, because ultimately it's the line manager essentially who should be leading the meeting. And, HR in an ideal, perfect world would be there to support the process, make sure the record keeping is happening and all those good things. Often what happens when we get involved, and that's an HR business, is that if we're handling complex matters, we'll do a lot of the leading. And that's because the line managers don't have the sufficient training that we've had as HR practitioners. So, in terms of training, what I'd be looking at is making sure that line managers have at least a top level understanding of long-term sickness absence, how that can potentially strain to people being considered disabled within the meaning of the Equality Act, and then being clear on the process. So the line manager needs to be, when they're handling those meetings, they need to be clear on why they're holding the meetings and the purpose of those meetings and how they should show up, essentially. I hope that makes sense.
Do you consider formal meetings home visits? Jackie's asked.
Yeah, I would. A formal home visit. If you're popping in just to do a hi, how you doing? It's kind of a friendly catch up. That might be different. But if you're holding a home visit to assess how that person is doing, to talk about their health condition, for me that's formal, and you should be minuting that and capturing relevant information.
So Joanna said she tends to contact long-term sick employees via phone on a weekly / 2 weekly basis to say it's only HR. Would you still advise to go more formal?
So to make them formal or do more? Sorry, Jo, I missed that bit.
Sorry. Would you still advise to go more formal than that?
Well, I think later in the process, I would be inclined to hold more formal meetings where maybe there's you and a witness. What I would absolutely recommend is, if you're later in the process and you're thinking, I'm not sure whether this employee is actually going to be able to come back to work, then what I would absolutely suggest is you hold more formalised meetings where there is you and one other to act as a company witness, and to make sure that record keeping is happening. It's very difficult to do that when you're chairing the meeting. So in the early stages, that's really great what you're doing. All I would say is, later on, I'd be inclined to formalise it a little bit more, especially if you're going to look at dismissal. So it's just, and again, even with what you're doing now, make sure your record keeping is really good. And again, I would say to the employee, if you're taking notes, and even if it's just one-on-one and you're taking handwritten notes, type those up and tell the employee you're going to send them a copy of the notes and just ask them to sign them, and pop that on the case file.
Nicola's asked, what if the employee refuses to provide consent to seek medical input or occupational health?
Yeah, we deal with that. We do deal with that a lot. I mean, my first response would be, if someone's refusing, as I'd want to know why. And it may be that they are in a really difficult place. They can, they're dealing with, long-term ill health. So that's potentially going to impact their mental health and well-being more generally. And so I would be asking the question, what's the barrier for them giving us access? And I think, it's a good opportunity just to explain to them that us wanting access to medical information isn't about us making an automatic, gathering information so we can support our decision to dismiss. Our genuine approach here should be, can we get this person back to work? And if not, after we exhaust that process, you might need to look at dismissal. So if the employee says no, what I would absolutely do is say to the employee, look, it would be of benefit to you, in our opinion, for you to allow us to have access to medical information, so we can, understand how we can better support you. If they persist and say no, what you need to do is inform them that, look, ultimately, at some stage during this process, we may have to make decisions, and we can only make decisions based on the information available to us. So if you don't give us access to that information, we will only be able to act on what we have available, in front of us, and that could shape our decision-making process. So it's really important you capture that in writing as well, that you explain to the employee that it could be to their detriment of, them not making available medical information, because it may be that their GP or occupational health are going to say, actually, Mr. or Mrs. Employer, if you make these adjustments, the employee could return to work. And, you potentially actually, we can make these adjustments. Happy days. So it's just about making that clear. But my first go to always, why what's the challenge around allowing us access? Can I help, reassure you that this is actually in your best interests, and then go from there.
Nikki's asked, if the occupational health and GP report doesn't give specifics on return to work timeframe or reasonable adjustments, is it a case of the employee making a decision if the employee is capable of the role via a capability process?
I mean, it's an interesting one. Ideally, I would, I might be inclined to go back to the GP and if you specifically ask for that information and you've made available to the GP when writing to them to request access to medical records, a copy of the employee's job description, I'd be inclined to go back to the GP and say, hey, I've asked you specifically questions around likely return to work and so on. If that's not available, it may be that you refer that employee to your own occupational health specialist to get an opinion on that. I would be reluctant to rely solely on an employee's opinion. I would be wanting to get support from a medical practitioner. If that's not the GP, then an occupational health specialist. I hope I've answered the question. Was there something I missed off at the end, Joe?
No, that's fine. So another question, what if the medical evidence is ambiguous in terms of return to work likelihood? How long do you need to keep a role open for before considering dismissal?
Yeah, and it's a really good question. It's a really common question. And it's going to make it sound like I'm being really vague, and that's not my intention, but it really depends on the specifics of the case. But I mean, typically, in my experience, when we're at the point of dealing with dismissal, it's normally at around the 12-month window. As I said earlier, we have dealt with a case where we dismissed somebody at 9 months, and that was appropriate in circumstances. That was also quite a clear-cut case where the employee themselves kind of saying, yeah, I don't think I'm actually going to be able to come back to work, and the GP was in support of there's no foreseeable return to work date, so it was considered reasonable that the employer couldn't keep the job role open. So that what I would say is, yeah, there isn't a specific timeline, but typically in my experience it's always normally around the 12-month window for the cases I've handled. That's how I look at that.
What if the reasonable adjustments aren't commercially viable for the business, therefore they can't implement them?
Yeah, and that can actually happen. And what I would always say is, if there are reasonable adjustments that the business can't accommodate, just make sure you can objectively justify why. And that's often where I think employers can fall down, is when they say, no, I can't accommodate that. Is I always say, well, tell me why and give me the detail. And so when I work with clients, they get some, and I think look at them and think, oh, it's 101 questions, but they say, no, I can't accommodate that. Why? And they say, well, it's the cost. Tell me about the cost. What does the cost look like? So the reason I do that is not to be difficult, but it is just to make sure that if you are challenged in the tribunal, in the employment tribunal, the employer can stand up and say, actually, it was because of these reasons. So as long as you can, you're not obligated to make reasonable adjustments if you are not able to do so. All you need to be able to do is objectively justify why.
What is the difference between ill health retirement and dismissal for long-term absence in terms of company process, particularly in terms of notice periods and which party provides notice?
Yeah, that's quite well, let's deal with the difference. So ill health retirement is different in the sense of you're not dismissing the employee. They're basically going to be accessing benefit under their pension scheme. Now, I'm not an expert on pension schemes, so we would take advice around whether the employee has eligibility to access their pension benefits early, i.e. retiring early due to ill health. If you're dismissing for ill health, essentially you're terminating the employee's employment, you're giving them relevant notice periods, so i.e. don't overlook contractual notice periods and certainly don't overlook statutory notice periods when you're dismissing. But the two are different in the sense of ill health retirement is the employee accessing their pension benefits, whereas when you're dismissing someone, you're actually saying, look, we're terminating your employment, here's your relevant notice period, and after the notice period has expired, they're no longer an employee, they don't accrue holiday and pension benefits and all those sorts of things. I hope that's answered your question. I think that's what you asked. Email me if you've got more questions, feel free to email me.
What if the employee's health situation is impacted by awaiting further treatment from the NHS, which is delayed due to availability?
Say that first bit again, sorry, Joe.
What if the employee's health situation is impacted by awaiting the further treatment from the NHS, which is delayed due to availability?
Yeah, so I think, if you've got an employee who is saying, look, my health condition could change in the near future once I've had this treatment, what I would recommend you do, certainly if the treatment's within the near future, is you would expect them to have that treatment, because I don't think you would be able to defend say dismissing, and being able to, suggest that's reasonable. So if the employee is saying, look, I am hoping to return to work, but because of the current situation within the NHS, there are delays on me being able to access treatment, I would suggest we wait, would be my advice. Or certainly if you're saying it's really not possible to wait, I would take specific advice, legal advice on that, because my view would be is that, we would wait and allow them to have their treatment first.
Can we send a summary of the meeting by email and ask them to confirm accuracy?
Yep, I do that. We actually, as a team, I would say now, we probably do that 90% of the time. It's very unusual for us to send actually notes and get a physical hard copy sent back in the post. So what I would do when we're handling case matters for clients is I will send notes, for example, in a PDF document and say to the employee, we don't even have a signature strip now. I put my signature on them because I have an electronic copy of my signature, so that goes into the document. I then email them to the individual and I say to them, please find attached the notes from the meeting held with you today. And can you please come back by return email to confirm that you have reviewed them and that you are happy that they serve as a fair reflection of the key discussion points from our meeting. And then what I would do is print a copy of the notes, print a copy of the employee's return confirmation email and stick them to the front, put them on file, and that's sufficient.
Annette's asked, does the employee need to see a copy of the specific questions that you send into the GP as part of their consent?
Yeah, when we write to the employee and say we want access to their medical records, we do explain what information we're looking for, because I find that's often helpful for the employee. So yeah, it's just being upfront and clear with them. These, we want access to medical records. Normally there is a standard template that we use, and we obviously amend that depending on the situation and the client. But yeah, we shouldn't be employees should be clear on why what we're asking, what we're looking for, essentially.
So Sophie's asked, what if you don't have business PHI, but they have personal PHI schemes?
Or taken out separately to the business?
That's what I would read that as, yeah.
I'm dealing with, that's a good question. It's not something I've ever been asked before. I would suggest that if they've got private PHI, that's between them and the insurer, and you carry on with your process, including dismissal. The only time that you wouldn't want to do that is if you've got a company PHI scheme in place, and then that would absolutely change the situation. We've got a client that actually has a PHI scheme, and for example, 2 years ago we had to work with the client, and it's quite an onerous process to get the insurer to accept the employee met the criteria. But that employee is still employed by the company, but they're on the PHI scheme. So the employer isn't paying them salary; they're getting, I can't remember the percentile; it's a bit higher than 50%. I think they're getting something like 55% of their annual salary on that PHI benefit. But in terms of if it's a private scheme, the private scheme wouldn't have been procured by the business, therefore it wouldn't impact employment, in my view. Happy to be challenged if I'm wrong on that. It's not, again, my all I would say on that is if you've got a specific example you're working on, just take some advice. But my view would be, if it's a private scheme, it's nothing to do with the employer.
So a long-term sick employee returns and reasonable adjustments are put in place. What if the employee goes off again for the same reasons? Can we proceed with medical capability, or do we have to go through the full process from the start again?
No, I wouldn't go through the full process again. If they return, you've made reasonable adjustments. Sorry, let me start again. They've returned, because you've made reasonable adjustments, and they go on sick leave again quite quickly. I'll treat it as a continuation. I wouldn't treat it as, we're starting from ground zero again. It would be different if they had been back in the business for, a year, for example, and then they suddenly go on sick leave again. I would say no, you wouldn't want to. You might want to start maybe more from a fresh, as it were. But let's go on the basis of they've gone on sick leave fairly quickly after returning, treat it as a continuation. And I wouldn't automatically jump to dismissal. I might, just touch base again with the employee, look at occupational health and so on to support any decisions you make. But definitely treat it as a continuation, not as a let's start from the beginning all over again.
Nathan, I'm just conscious of time. There is still quite a few more questions to go through. Is this something that you want me to email you and take offline, or are you happy just to carry on for the time being?
I'll work for you, Joe, until you tell me you've got to go. I know you've got other things on, but I'm happy.
Right, that's fine, no problem. Okay. Okay, so would dismissal be considered reasonable at the end of the PHI claim period?
Well, if the PHI claim period has ended and the employee is no longer entitled to receive that benefit, then yeah, you can't continue open-ended having them on the books, as it were. So again, but what I would suggest is that you look at the specifics of the scheme and you check their contractual entitlements to any other benefits, for example. I mean, yeah, that's what I would suggest you do. But certainly if the scheme has ended and they're not entitled to any other benefit, then absolutely what you would want to do is then look at, well, how do we proceed? And it wouldn't be realistic to keep that person as an employee open-ended. And the risk would be removed in terms of, essentially with PHI schemes, there are specific cases where, it's given rise to a breach of contract claim. But often the PHI benefit is seen as, this is income that an employee could have and they're entitled to. If that has ended, then you haven't got that potential claim that they could make. Again, always with what I would say is always takes advice where, someone can access the detail, the nitty-gritty to give you an informed opinion, but that's just the top level view.
In the situation of the employee returning to work after long-term sick and not working to standard level or adhering to the full job description, would the dismissal be reflected on the employee's performance rather than long-term sickness, or would all need to be factored in?
Well, I mean, you again, we're talking about, it would be a capability, essentially. So if the employee is working on reduced duties or amended duties because of their health condition, essentially, and that's now ongoing, and they, especially if you made those adjustments and it was a temporary adjustment, and you're now in a situation where the employee is saying, well, actually, I can't return back to normal duties, then what you're dealing with is a capability situation. And it's a continuation of the long-term absence process that you've managed. So essentially, if they've returned and they're now saying, well, I can't return to normal duties, then you've got a capability issue that you need to address with them.
Rachel's asked, if an employee is exhausted company sick pay and SSP at the point of dismissal, would you pay the notice? Would you pay the notice pay in full? Yeah,
because if their notice period falls outside of their sick pay, then they're entitled to notice at their normal pay. So you pay up their notice period. Does that answer that question?
If the relationship with the individual is broken down irretrievably, can due process be bypassed and the employee dismissed due to SOSR?
No, I would recommend no, not when you're dealing with long-term sickness absence. So if the relationship is broken down irretrievably, I would need to understand why. How has that happened? But I certainly wouldn't just be looking to dismiss for some other substantial reason. I would suggest that you would take specific advice, and we'd need to look at, well, how's the relationship broken down, and what steps do we take from there. So it's a bit of a difficult one to answer without getting into the nitty-gritty of it. But my immediate response is no. If you've been dealing with long-term sickness absence and these issues have arisen during your management of that I wouldn't be looking to then dismiss them automatically for SMSR.
Nicholas said,
I would say.
With an employee on long-term sickness coming up to 4 years, they were awaiting a second liver transplant and are being paid by our company PHI. The PHI would switch to a direct payment basis rather than paying us. This would change the basis of their cover to being considered unfit to do any job rather than the existing job. We have no prospect of their return to work. This could go on for another 2 years plus. What would you recommend?
I would go and get specific advice, get some professional advice on that situation. Even we in circumstances such that would consult with. I have, as I said, I've got an employment list in my team who's they're not practicing law because we're not a law firm, but I also have a law firm that I partner with, and so we, in those what I would consider to be really complex matters, we just get legal advice, because that's definitely would fall into the realms of disability, and that's something you should take advice on, because that can be really costly if we get it wrong. So take professional advice would be my view on that one.
Annette's asked, would you allow them to work from home if they are not well enough to travel to work? Can you ask for medical records in these cases, i.e. well enough to work, but not well enough to travel to work?
Yeah, so there's a number of things in that regard. Is yes, you can allow people to work from home if that's right for business. But if you need people to, if the role of that particular employee requires that they do need to be on site, then there's nothing wrong with saying to them, well, look, actually, we can't accommodate you working from home. What I would look to do in that situation is to write to their GP or go to occupational health if you've got an occupational health specialist that works with you, and explain to them the employee's job role, explain that they need to be on site, we can't accommodate them working from home, and ask a specific question. The employee saying they can't travel to work, why is that? And does the medical practitioner support that? So the starting point is ask the employee why they can't travel to work, what's preventing them, how long do they think that's going to be lasting for, and then if you've got concerns, get a viewpoint from a medical practitioner. And just as another point for anyone that's still online, we sometimes often run into problems or challenges with these kind of specific issues where an employee says, well, actually, I could come back to work, but I can only work from home, or I can only do this. What we say is get some support get a view from a medical practitioner. And sometimes the employee will say, no, I'm not giving you access. And in those circumstances, do all the things we talked about, explain to the employees and their benefit to allow you to have access. If you still can't get access, with the occupational health provider that we work with, they will provide us what they call a medical legal report. And so what we're able to do is say to them, and it's kind of a very general, almost like a hypothetical one. We say to them that we've got an employee, that they've got this health condition, this is how long it's been going on for, they said they can't do X, Y, and Z. Is it reasonable for us to accept that that is the case? What would your view be, if you were looking at a case, of a male or female's case and be of this age with this condition? And they'll then write a report, say, actually, I don't accept that, their health condition would preclude them from traveling, for example. So that could be helpful, because then what you're doing is saying, look, they wouldn't give us access to a medical report. So we got the next best thing, which was like a medical legal report, which was giving us an overview of what would be reasonable for us to accept. I hope that helps.
So there's a couple of people asking, do you have to go to the GP, or is an occupational health report acceptable?
No, an occupational health report is acceptable. To be honest with you, I like to do both. And the reason I like to do both is it depends on the health condition. But, if the employee's got a really good GP, there's nothing quite like getting an overview or a viewpoint from someone's primary care practitioner. And so for me, it's definitely worth getting a report from the GP as well as occupational health. Sometimes occupational health is sufficient. It depends on circumstances really, but as long as you've got reports from occupational health as a minimum, I'd say yeah, fine. My view is though, let's go belt and braces. Let's get an overview from the primary care practitioner and then occupational health.
So if a decision has been made with all the available information, i.e. an employee has refused access to health records, and the employee appeals the dismissal, do you have to reverse the decision because the employee has now decided to share their medical information? Yeah, that's it.
Well, that's a good question, because I've actually never dealt with a case where that has happened before. I would be inclined to take some advice on that. And the reason I say that is it would be difficult not to overturn the decision to dismiss if they've given you access to medical records and that information makes a substantial difference to the decision-making process, if that makes sense. So I think if you get a medical report that says actually the employee is able to return to work, maybe might be with adjustments for a temporary period, would you then be able to defend not overturning the original decision to dismiss? That is a good question. I would say take advice, just on the safe side, because that's my thinking. Unless someone else has got a view, feel free to share.
So if the employee is taking ill health retirement, does the employee need to resign?
What, from their job role?
I'm assuming so, yeah, that's all.
No, I would say what I would do is get them to, if you've reached a mutual decision for them to go to retire for ill health, just capture it in writing. I don't think they need to make the employee write a resignation letter in that way. What I would do is just capture the narrative of it's been, we've all reached the decision that the employee is going to retire on ill health. Now, if it's a requirement of the scheme that they resign, then fine, follow the process. But as long as it's documented that that's what's happening and you can all refer back to it, then fine. But again, ultimately, it is following the process set up by the pension scheme provider with whatever
Right. I have two more left. So Joanna's asked, for an offer of alternative employment, if a new role is paid less, would it be reasonable for the company to not keep a higher salary from the previous role?
Yeah, that's a good question. My view, my advice would always be that you would red circle their salary essentially, because you wouldn't want the employee to potentially claim that we, the business, have demoted them as a result of their disability. And let's talk about now. I'm going to specifically say disability because typically with long-term sickness absence, you're looking at someone with a disability. So you don't want to give rise to them saying, I was demoted because I have a disability. What would the best course of action, I believe, would be put them into the role and then red circle their salary. Wouldn't be reasonable to carry on giving them pay increases whilst their salary is above the role that they've gone into. But if you can demonstrate, look, we're going to red circle it, then that's the safer option. But if the business was really adverse to that, then again, just we take advice. And the reason I always say that, it's not that I'm being intentionally vague, but it's not until I can see all the information I can start making informed decisions. But my normal approach would be keep the salary where it is, red circle it, and then that just negates any potential claims.
How many weeks absence would you think is reasonable before you ask for a medical report?
Well, I mean, once they've triggered long term, I mean, so let's if we say right, they've typically the GP will sign off in blocks of 2 weeks. So I think once you start getting to 6, 7, 8 weeks, I might be inclined then to say, okay, let's talk. It all is case dependent, of course. So have communication with the employee and ask them for their input around when do you think you're going to return to work. If the employee says I'm going to be back to work in 6 weeks, and you find yourself at 8 weeks, start getting, you can start asking for more information from their GP, for example. So again, it is case specific, and I'm not being vague deliberately. But what I would say is, get a steer from the employee about when they think they're going to come back to work, and if you go beyond that point, then that's when you can say to the employee, look, we want to start understanding what we can do to help you get back to work. Let's speak to your GP. Let's get some helpful information that can support that process.
There's a couple more. Come on, Nathan. So Phil's asking if there's conflicting reports, one from occupational health saying the employee is not fit for certain aspects of the role, and one from the company's physio saying the employee is fit for the role. Which advice should you take?
Oh, that's a good question. That's again something I've never had to deal with, luckily, in my career. I mean, my viewpoint would always be that you would look at the specialism of the person giving the advice, I guess. So if the physio is saying that there are mobility issues, if the occupational health specialist isn't necessarily skilled in that area, I'd be inclined to go with the physio, because they would be dealing specifically with mobility issues. But ultimately you could always go back to occupational health and say to them that this is the report we've had, it's conflicting, and you could ask your occupational health provider to give you a second opinion. That might be the more senior occupational health specialist, for example. But again, if the physio is saying, look, they're not fit for work now, they're going to be fit within 2-3 weeks, then I'd probably be inclined to go with the physio and give the employee the best possible opportunity of returning to full health. Obviously, if you're dealing with something that's becoming a bit contentious and it's been ongoing, then you might want to look at a second opinion.
Right, this is the last one. Pending medical intervention, would you be able to dismiss with an open door to return once recovery has taken place?
And pending, was it, sorry, Joe? Pending.
Sorry, I'd gone off it now. Pending medical intervention, would you be able to dismiss with an open door to return once recovery has taken place?
No, I mean, I would suggest, and again, happy to be challenged on this, but if you've got someone saying, look, if I have treatment in the near future and I'm going to be able to make a full recovery, it wouldn't be reasonable to dismiss. So if as long as you know that treatment is due within the near future, i.e. you've got, a specific date, the employee can demonstrate that they have been referred for that treatment and so on, I don't think you'd be able to defend a decision to dismiss. Now, that being said, if you were dealing with a hypothetical, the employee saying, well, if I have this treatment, but there's actually no plan on the part of the medical practitioner to make a referral for that treatment, therefore it's kind of a wishful thinking scenario, then that would be a different kettle of fish, because essentially the employee is saying, well, if I have this treatment, I could make a full recovery, but actually I'm not eligible for that treatment, or my medical practitioner hasn't made that referral, and that's not something that's really open to me. So again, I think it is really situational in terms of, if they've got referral and treatment is pending, and you can see that they're on a waiting list, for example, then no, I wouldn't recommend them dismiss. Is my view.
That's it. Is there anything you want to say, Nathan, before I do the close?
Yeah, no, I just want to say thank you to everyone for your time. I appreciate everyone showing up and being so invested in the process. As I say, if you've got specific matters you need advice or guidance on, feel free to get in touch with us. There's myself, who heads up the team, but I've also worked with Deborah West, who is former employment solicitor, but who's now one of my senior consultants. I also have John Stembridge King, who's a trade union specialist. So there's very little amongst the three of us that we haven't dealt with over the years. So if you have any specific needs and you want to get professional advice, feel free to contact us. My details are on the slides. I know Joe will send them out. But as always, it is lovely to meet you all. Feel free to add me on LinkedIn, guys, and follow us, because we tend to post a lot of information on our business page, helpful hints and tips and stuff. So thank you very much.
Thanks very much, everyone. I'll send out some correspondence this afternoon to everyone that signed up for the meeting, and I'll put a post on LinkedIn. So if you would like a copy of the slides or the recording, then please put a post on the LinkedIn comment. Our next event is on the 29th of March, which is the cost of living crisis, our finances and well-being. A link to sign up to that will be contained in the email. We've also got a guild networking group for HR professionals. I know some of you are already members of that. It is a bit similar to WhatsApp, where members can ask questions and network. So I'll put a link to that on the email. And if anybody is recruiting, we've also got accountancy recruit and finance director recruit within the group. But other than that, I'd just like to say a massive thanks to Nathan for your time and effort into putting the webinar together. I know there's been some really good comments in the chat. And also thanks very much to everybody for tuning in. I really appreciate it. Thank you.
You're very welcome. Thanks, Joe, as always.